Hi, my name's Becky. I'm one of the directors here at Bourne Estate Agents. Just wanted to run you through how the new legislation might look. So there are many parts to the Act. I won't go through all of them now, but I'll just focus on the ones that probably mean a little bit more to the clients. In essence, it's going to be abolishing the Section 21. A Section 21 is a no-fault eviction, which means you can give notice to your tenant without offering a reason to that. The change here will be that you now need to have a valid reason to get a tenant out. And you would use a Section 8 notice, which is currently in existence, and we use it at the moment. But they will be extending that Section 8 in order to allow extra reasons to get your tenant out, such as if you want to move into the property or if you want to sell it. But the Section 8 does cover a lot of different reasons as to why you might need to get your tenant out, such as a breach of contract, or if your tenant is in arrears as well. So that's kind of the main basis of what they want to do within the Act. So the Act is trying to make pets more commonly accepted and probably change a bit of a mindset within rented properties. Post-COVID, lots of people have got pets, lots of people work from home, so they're just trying to kind of make that a bit more normal. If obviously you've got restrictions in your head leases, they will be upheld. Also, potentially, if you've got allergies and things like that, they should be an okay reason to refuse a pet. However, if you have to allow a pet, there will be landlords will be able to request tenants have insurance, which should cover if there is any damage caused by the pet at the end of the tenancy. No, you absolutely will be able to get your property back, but you just need to give a valid reason in order to do so. That's the main change. Most landlords that we deal with have a valid reason in order to get possession of your property, such as arrears, such as breach of tenancy, wanting to sell, wanting to move back in. So those will all be valid and all be absolutely fine in order to serve your tenants with the notice. Some of the notice periods are extended. So as an example, if you want to get your property back to sell or to move back into it, you have to give 4 months notice. So you do need to have a bit of foresight in terms of what your long-term plans with the property are. You also have to allow the tenants a minimum 12-month period before you can give any notice. So again, just having that foresight and knowing what your long-term plans with the property are going to be key. So the tenant will need to be 3 months in arrears within the new Act, and you would need to then serve 1 month's notice. So in effect, before you can start any legal proceedings, you would need to be 4 months in arrears. So whilst this does sound concerning to a lot of landlords, I would probably say a way to counteract this is to make sure you have rent protection insurance, and that's going to be key moving forward within this new legislation. They want to bring it in by summer next year. We're in its second reading at the moment. So we've got a few more phases to go, but their hope is that it's going to be summer next year. I would personally advise that they don't sell their portfolios. This is just a change to get used to. It's not as scary as it's first made out to believe. So once everything settles down, it will be kind of back to normal. We should be getting some really, really good rental returns, and we should be getting some really good long-term tenants as well. So it is a real benefit to those landlords who have multiple portfolios or even just a one-off property where you can see kind of a long-term future with that portfolio. We at Bourne will absolutely try and keep you on top of what's going on. We're in its very early infancy stages, as I mentioned earlier in the Act. So we will absolutely make sure that we stay on top of things for you and relay that information across to you as and when we can. It is a good time to think about getting a managed contract, just so we can make sure that your property is fully compliant and continues to be compliant as we move into the new Act. If you have any further questions or you need any more advice or help on this, please do speak to the manager of your branch. They are fully versed in all of the new legislation, so should be able to help you out with any questions that you might have. Thank you very much.